Good evening and welcome everyone. My name is Victoria Fisher and I'm the program assistant here at the Institute for Intellectual Property and Social Justice. Thank you all for joining us for tonight's session of Intellectual Property for the People webinar series. This series is a free webinar series designed for and marketed to creators, inventors, and entrepreneurs from communities of color who have historically and continually been locked out of receiving key knowledge and resources related to protecting and profiting from their ideas. In this series, we offer easy to digest and engaging talks on IP rights and navigating the IP system, highlighting tips and resources via live webinars, which are saved as an on-demand video series on our YouTube page. Tonight's webinar is directed to innovation in IP and further how to monetize ideas even without seeking patents, trademarks, and copyrights. We're glad you're here for tonight's session and hope that you'll join us for future sessions. Please sign up for our newsletter to ensure that you're notified of future events. And now I'll turn the program over to our session moderator, Marnitia Walker.
Hi, good evening. My name is Marnitia Walker. I am a current 3L at Southern University Law Center, and I've had the pleasure of working with the USPTO over the summer, which is how I got in touch with Victoria, and I am excited to be here, and I will be moderating this panel. If you have any questions, please drop them in the chat, and I will present them to our panelists.
Okay, I guess we could start. I'm Lawrence Cosby. I am a former patent examiner, so I too have that connection to USPTO. Currently, I am the Vice President of Intellectual Property Strategy for the corporate division and also Intellectual Property Counsel at JP Morgan Chase. My job there is to preach the good word of intellectual property, especially patents. Get our global technologists all across the world to understand that their innovations should be protected and are special and could be patented. I work with them to develop their ideas, make a determination on whether or not we should file a patent. Now, as of recently, I also work with our outside counsel in drafting the patents, going through patent prosecution, and managing our patent portfolio. I'll pass it to Clinton.
Good evening, everyone. My name is Clinton Mitchell. I am the founder and CEO of Diplomatic Enterprises. We are a full-service consulting management firm that specializes in working with legal, branding, and operations. Essentially, my job is to cultivate relationships, devise strategies, and supplement the existing structure of a brand to help them become the best version of themselves. Like, we work with athletes, brands, and creatives on essentially just helping them get started or progress to next. And a large part of our portfolio, it deals with intellectual property. So it's not just registering copyrights and trademarks, but it's actually the strategy behind doing that. And that is what I've been doing. I'm a graduate of Howard University School of Law. And I've been doing this work for a long time, about a decade and a half. So I'm excited to kind of share with you guys tonight and work with my good friend, Lawrence Cosby.
Yeah, I forgot to mention, I'm also a graduate of Howard University School of Law. It's where I found intellectual property. The Institute of Intellectual Property and Social Justice founder, Latif Fatima, was one of my mentors and told me that you were going to be in patents. Before I even knew what a patent was, my background was in computer engineering from Hampton University, and I thought I thought science and technology was behind me, and it's been my career. But I am grateful. The reason why I wanted to have this conversation and work with this program is because of the historic disenfranchisement of people of color when it comes to protecting of IP. There's this quote from Halle Watts that says, "There are entire culture narratives getting erased by unscrupulous and illegal IP practices. And even though we've seemingly race-neutral laws, there is a pernicious false conviction that people of color are less creative and less expert. We must decolonize, by which I mean unseating the stubborn and deceitful belief that people of color are not full people who are capable of creating intellectual property." And if you really understand the history of intellectual property, especially in the United States, people who were considered property could not create intellectual property. Anything they created with their mind was owned by those that owned them. And this also includes Native Americans, their indigenous cultures, beliefs, improvements, technology, innovations were not seen as creative or innovative. But now we have this herbalism and the likes, and we see that they understood a technology that was natural. Um, First of all, before we even go into innovation IP, we do have to kind of level set and to understand what are the different types of IP. I know some may know them already, but we have to allow everyone to really get a handle of them. And I'm going to let Clinton talk about copyrights and trademarks.
So Kaz is doing me a favor by letting me lead off with copyrights and trademarks because they are the two of the quote unquote easier of the three. If you understand patents, more power to you. But they are definitely something that you should be an expert in, and I am not an expert in patents. And anybody tell you differently is definitely lying to you. But in terms of copyrights, how it works, they protect the expressive arts, right? So poetry, songs, literature, and they give ownership, exclusive rights to reproduce that work. So one of the most common things that I get approached about in terms of copyrights is, hey, once I create it, like, don't I have, a natural copyright? And yes, once you create a thing, you do have ownership, you do have a copyright in it. But one of the benefits in registering a copyright is the protection that you are afforded by the US government and other government agencies across the world in the sense that you register with them as well. But as it pertains to the US Copyright Office, like once you register your copyright with them, you afford certain protections that you won't have if you never, file that song or that poem or that novel, with the US Copyright Office. So it essentially will just allow you to protect whatever expressive art that you've created to the nth degree. And it is important to note that copyright protection does have a finite amount of time. I would love to tell you that it is the life of the author plus 70 years, except for in cases that involve Disney, where they get to kind of set the rules as they go along. But essentially, that is how that works for the rest of us commoners. In terms of trademarks protect the names and identifying marks of products and companies. And the best way to kind of understand is that the purpose of trademarks is to make it easy for consumers to distinguish between companies, right? One of the several tests that the U.S. Patent and Trademark Office will use when they are trying to review your application for a trademark is the likelihood of confusion in the market. And one of my favorite examples of something like this is when the basketball player Kareem Abdul-Jabbar essentially contested a football player named Kareem Abdul-Jabbar from getting a trademark of his own name. The names were spelled differently, but the elder, Kareem Abdul-Jabbar, the basketball player, was like, nope, it's too much like me. I'm bigger, I'm older, I'm more famous. And essentially, USPTO ruled in his favor, said that the football player could not get a trademark of his own name. And the reason was the likelihood of confusion in the market. So you want a trademark so people can that lessen the likelihood of being able to confuse your candle company, your shoe company, your consulting company from someone else with a similar name. And that's just essentially the crux of it.
Definitely great. I do want to point out a couple of things that Clinton was saying. With that copyright, it's life plus 70. So that is your natural life. After you pass, there is still a 70-year time period in which your family, your organization, your lineage can still profit from that. And so we talk about generational wealth. 70 years is generations. After you leave this moral coil. Also with the trademarks can be renewed indefinitely. So you leave your business to your child, it continues to go on and on as long as they continue to stay in business and pay their fees. So they have that lineage and the ability to profit from your hard work as a business owner. I get to the tough ones. I'll take the easy one first, which are trade secrets. Trade secrets are typically something that's not generally known to the public. There has to be reasonable effort made to keep it confidential. and it has to confer some kind of economic value. So there are a lot of laws. There isn't a place where you go and you deposit your trade secret. If anyone tells you that, then they're a scammer, and you're going to lose protection of trade secrets. Some examples include, the formula for Coca-Cola, or the 11 herbs and spices that are in Kentucky Fried Chicken. Some can also include banking formulas for giving people loans, or choosing select stocks and hedging, or even your book of value, your phone book, some of your techniques in your business of how you're doing something that is special and unique. And as long as you keep those trade secrets and have a reasonable effort to make them secure, you can still have those protections. Patents are kind of the opposite. Patents are, you actually have to tell everyone what you're doing. Patents, they can be a machine, a process, an article of manufacture, a plant, and some designs. And these are really recipes for someone else to build down the line. But when you do file a patent, you get a 20-year monopoly. You get to license it, sell it, prevent others from using it, importing it, etc. So you get to the protection and the backing of the US government. What you do have to give up is that technology, is that innovation to the government, and they'll print it out. They'll have a printed publication. They'll have a printed patent. So people generations from now can build upon that. All of these intellectual property laws are to promote the arts and sciences. You're giving the world something, and in return, you're getting something. Hopefully, some financial windfall. But if not, you're in the annals of history of somebody that's created something. So yeah, but all of this starts with innovation. And innovation is definitely, one of my favorite things in the world. I believe that everybody is innovative in their own way. Some people believe they're not creative, but it depends on the medium. And that there's life as a medium, business is a medium, arts, of course, and sciences. I like to call what innovation efficacy. And for me, innovative efficacy is a person or group of people that have the trust in their own abilities to create something new and useful, and a belief that they can effectively navigate the innovative landscape and those charged with protecting intellectual property. So you can have internal efficacy, where it's the belief in oneself that what I create is something special. And you can have external efficacy, that the belief that government, institutions, businesses, et cetera, will protect and attribute those creations accordingly. I do want to have Clinton talk a little bit about his innovative process for himself. Don't share any trade secrets, but also, your innovative practice with your clients.
So essentially, kind of what we do is, like, we take clients from beginning to end, right? And at the beginning of my practice, about 13 years ago, like, a lot of our clients were at the beginning, who needed help, like, getting their company formed, right? And now the bulk of my clients now are what I would call next clients, right? Clients who have done everything that they can to get to where they are, but they need help getting to the next level, whether it is a wholesale order with a big box store, or whether it is scaling to 10x, 2x, whatever the case may be. And what we do is, and a lot of times in those cases, intellectual property is at the center of what they're doing and how they're doing it. And if they took all the painstaking steps to do it the right way at the beginning, it's an easier process. It's still work to be done, but it's an easier process. But if they haven't, it's a lot of going back to make sure to see how the trademark application was filed, if it was filed, what we're doing, because before you get that product into Target, they want to know if you own the intellectual property, right? Like, if you have a logo on a lipstick, and you want to put it on the shelves, like, do you own the IP behind it before you put it on the shelf of a Walmart or a Target? And if not, that's something you need to do immediately. So one of the things that we do when clients, whether they're looking to bring us on a retainer, meaning we represent their interests day in, day out for a certain number of hours, or indefinitely from now into the contract expires, or clients who I like to call, term limited, like they're one-offs, like we're just here to do a copyright application or a trademark application. Every single one of those clients gets an opportunity to get a strategy. Hey, Clint, hey, Diplomatic Enterprises, like we want to file a trademark for a thing. I was like, okay, so how do you plan on using it? Today, next quarter, and then 3 quarters after that. Because the how you plan on using a product or marketing your services will depend on how that application gets filed with the US Patent and Trademark Office as it pertains to a trademark. So we add strategy to every single thing. And I think that's one of the things that we do that's very unique compared to other similarly situated firms. We care about what you're doing and how you're doing it to kind of help you move forward. Because whether you ever hire us on a retainer or not, right, we still want you to put your best foot forward. We want you to have an opportunity to help create generational wealth. And one of the ways you do that is by owning intellectual property. And I'll let Kaz talk about how his vision of intellectual property as it pertains to other areas of property law. But he and I both are share similar sentiments about the importance of it in our community and in our respective practices.
Absolutely. My role is a little different because I'm working in-house. So my clients are JP Morgan employees. Anyone that has a great idea that is within our corporate space. I'm really focused on the back-end technology. I'm focused on cybersecurity. I'm focused on data sharing, artificial intelligence, blockchain, user experience, anything that's really behind and supports the business. That's what I do. Some of my colleagues, they work more in the banking part, the consumer banking, the investment banking. So their patents are more focused on that. Mine are really technology. And JP Morgan is one of the premier technology companies in the world. You wouldn't know it because we don't advertise it. But if you're at that level and at that scale, you have to have that. And we have to solve so many problems. There's so many things that aren't on the shelf that are not accessible. So we have to build it in-house. Or if not, we have the idea to protect it. And what that also does is that allows us to license, allows us to build relationships with other companies. If we make an improvement on your product and we get that patent, we can come and talk to you and say, hey, would you like to license our patent for your work and give us a discount? Thank you, Salesforce. But my role, I really approach every submission because we have a great portal that anyone at the firm can submit to. And we'll review it and then have an interview with them to talk about their idea. But I approach every engagement with this is your baby. This is something that the fruit of your mind. Sometimes it's something that it has already been done. There's prior art out there, or it just doesn't fit the bank's direction. We do have laws and regulations that prevent banks from patenting a new spaceship or a car. Because of some fallout. But I try to be careful and I try to be understanding that those thoughts have value and that when a person, comes to me, it's a nerve-wracking experience. They feel vulnerable. But I don't want to stop them from innovating, even if you can't get a patent, because people look at patents sometimes as a zero-sum game. If you get a patent or not. But I look at innovation as a spectrum. Patents are just one color. A lot of innovations that we have every day are still viable and still helpful. One of my favorite things is when someone brings to me an innovation that is not patentable but helps other technologists, makes their job easier. Because what happens is that if you're making everyone else's jobs easier, they have more time to think and more time to ideate and innovate. And that allows them to create something new. We definitely engage multiple times with people, kind of see what you're working on. Because sometimes you're solving a problem, but your head is so in the weeds and you're doing your job, you don't realize you've created something incredible. And we pull that out of them. My job is also to help people visualize, what a patent is. When you file a patent, you don't have to have it built out. You just have to have enough technical detail that someone else can build it. So the analogy that I use is that sometimes people bring me their ideas, and it's like a grocery list. You got eggs, you got flour, you got milk, your sugar. I don't know what you're making. I know what you're going to pick up, but a patent is a technical document that is more of a recipe, not a grocery list. So you need to tell me how much I need to mix. You need to tell me the measurements and what temperature needs to be on, and tell me actually what you're making. That is when we're able to get something that fits the form factor of a patent. But also let them know, we want to look 20 years in the future. If you solve the problem now, what is the problem for tomorrow? Because why would you try to get a patent on the now and then someone comes in and patents the future, and now your patent is less worth. It's not worth less, but it's less worth. But as Clinton said, I like analogies because connecting. I like to say that intellectual property is real property. And real property, it's a little joke, it's a little nerdy joke for lawyers. Real property is the traditional property that you think of: land, houses, buildings, farms, etc. That's real property. It's called that. But also, I say intellectual property is real property because intellectual property is real. Even if you can't hold it, touch it, it still exists. It still is viable. And as Americans, this is our number one export. Our movies, our music, the creativity, a lot of our technology advancements. This is what we're making. This is what we're creating. Our books, the universes we create. But also in that, when you protect real property, you're building fences, you're locking doors, you're making sure that that real property is protected. But a lot of times people don't have that same mindset when it comes to their intellectual property. They're not locking the doors. They're not building the fences. It's kind of, and especially with the internet, we've never been in a space where the distance has been so shortened between ideas and usage. That exchange of information is fast. It's, when an idea of yours is here one day and in somebody's pocket the next day, because you didn't necessarily have those protections. So I do want to ask Clinton to kind of talk about what are these fences and doors and locks that he's helping his clients put on their intellectual property, even if it's something that isn't necessarily a copyright or trademark.
So that's a great segue. And one of the things I like to describe when we're working with clients is we're world building, right? And as you're building this world and as you imagine it, like you have to understand about how large the galaxy is, how large the universe is, and where your planetary idea fits within the galaxy of ideas. And then as you're building out your planetary idea in the galaxy of other ideas, how then do you grow it? Like how then do you protect it? And as he alluded to, is like there is a fence that you must build around your ideas. And one of the ways that many of us make missteps, particularly those inventors, creators of color, is we don't protect. We're not building the fences as we're building the ideas, as we're world building. And that is a problem. And to the point that it may, because it is such a short runway from idea to usage. So one of the things we always talk about is building a legal home for your idea. So that can be as simple as a single member LLC. You can go do that on your own in most states. Very easy, very straightforward. As an attorney, I would highly recommend that you research the exact form of company that you need, that best suits what you're trying to do. But for purposes of this talk or this chat, like it is as easy as just getting an LLC. And then once you do that, like you then have a place to park your ideas, to park your intellectual property, as opposed to under Lawrence Cosby, the individual, you can do it under Lawrence Cosby LLC. And then the next thing, one of the other things that we talk about immediately, right, is having an operating agreement, right? Like, how does this new legal thing that you've built operate? And I will give a very specific example. Like for the last couple of years, I have dissolved a number of different businesses. And I will give you an example of two of them. One had a very strong operating agreement. The Owner members decided they wanted to go their separate ways. There was a very strong operating agreement, and it was able to be resolved through negotiation. On the other end of the spectrum, very similar situation, except for the operating agreement wasn't strong and it ended up in litigation. And tons of money that was expended because there was no wherewithal, no forethought between, hey, what if this doesn't work out? And if it doesn't work out, what happens to the intellectual property? What happened to the stocks? What happens to the employees? What happened to the computers? What happened to the decks? What happened to the presentation? What happens to the products? All of those things that we must consider depending on the type of company that you have. So a strong operating agreement, which is generally not required in most states when you're forming a company, but I highly recommend it at the very beginning of the process. And then the other thing that I highly recommend as a part of that world building process at the beginning are non-disclosure agreements. Now, let's talk about what a non-disclosure agreement is and what it is. Okay. A non-disclosure agreement is a legal contract that limits the use and disclosure of confidential information, right? If you have a brand new idea for a rocket ship that's never been seen, never been heard of before in life, and you want to have a conversation with NASA, you want to have a conversation with Boeing, like it is best at that point to have a non-disclosure agreement. You have a brand new idea for an app, and you have all the ins and outs, but you need someone to actually do the design work for you because that's not in your wheelhouse. You want to use a non-disclosure agreement. That is just a couple of examples of the importance and use of non-disclosure agreements. What non-disclosure agreements won't do is protect illicit and illegal activities. And we bring this up because there are some people who believe, well, some parties who have since been criminally indicted and are sitting in prison in the great state of New York may be able to scapegoat or move around being prosecuted because there may or may not have been non-disclosure agreements. And that's not how non-disclosure agreements work. They cannot protect illegal criminal activity. Have a great idea that you want to protect, make sure someone doesn't ride off on it? Yes. You doing something else illicit or criminal? Absolutely not. That's not how that works. So, operating agreements that govern and rule how you run your company. And one other aspect I'll add about operating agreements, generally speaking, they are not public facing agreements. Like they won't see the light of day except for when they absolutely positively have to. It is really the internal rules of how you will run your company. So whatever rules that you guys agree to, again, so long as there's nothing criminal about what you're going to do with the intellectual property, how you will divvy up stock, how the shares are divided, is there a cooling off period, if the parties that be or that manage or own or operate the company decide to dissolve, like how will you do voting, like all of those things go into the operating agreement. And I strongly encourage you to put some thought, particularly if it's not just a single member LLC, like about what the rules of the road will be for this company. So the operating agreement, non-disclosure agreement, two very important things. And then more important than that, step one, again, having a legal home, creating a company for these ideas.
One thing I think Clinton kind of missed is a lawyer is important. For a lawyer.
That was self-serving, so that's why I left it out.
As I can say it as a person in-house, I'm not soliciting any business, but a lawyer like a Clinton are necessary for a lot of these things. And I love the concept of world building. I look at an operating agreement. It is that rocket ship. You're taking off. You're leaving, but you're going to make sure every nut and bolt is great. The materials are great because you don't want to be stuck in space like a few of our astronauts. I hope they're home. But also with that NDA, the NDA is your spacesuit because you're going out into the wild, wild unknown. You're going out with your idea and you want to protect it the same way you would want to protect yourself with that spacesuit. You want to make sure that you return home with everything that you have, all your limbs, all your vitals, etc. So you're going to need that NDA because there's so many times, so many people have this great idea and they just want to tell it. They just want to share it. And someone is like, wait a minute, that is a great idea. You did not bring me an NDA. I have no legal obligation because whatever you brought to them, but maybe not protected by the traditional intellectual property types. It's free reign, and with that, social media is it's the wild wild west. I will say a personal anecdote. I can say that I may have popularized a word that has been used globally, and I didn't want to protect it because I didn't want to own it because it wasn't mine. It was a word that was used in our community. It was something that we use it as a galvanizing call to action, call to understanding, call to awareness, and it took off in a way that I could have predicted, but I did not see a desire to own. Now I don't really regret it, but I can see why I should have owned that in that space. But that also goes to just show other intellectual property can include your social media account. Um, this is if you have a great name, you have a name for your business, go get it. Go get it fast. If you're gonna have a Pinterest, even if you're not gonna have a Pinterest for your business, get every social media account because a lot of times those are free. But also you can do a search to see if there's a business. If I want to start a hot dog company called Great Glizzies, and then I'm like, oh man, I typed it in, and someone has the hashtag or I mean the Instagram handle Great Glizzy, and they're also selling hot dogs. I got to go back to the drawing board because I don't want to invest all of my money in branding and merch and all of this, and then I realized that man, somebody already has all the handles, and getting a lawyer or if you're savvy enough, doing that trademark search before you go all the way in with your idea, because a lot of times we're pulling from the same pool of genius, and we're all receiving the same information from the universe. So you might not be the only person that has thought that thought. So it's definitely good to research that. I'll also say it may not be intellectual property, but it's still forms that of property that you should protect is a personally identifiable PI, personally identifiable information. You need to care about what your information is being used, especially in the world of AI and large language models. You should, if you want to opt out, opt out. Go to the settings and make sure that your information isn't being used by somebody down the line to take your voice, take your ideas, and feed it into a machine. Another one, is your identity, social, personal, protect your identity, but also your brand and your ideas. Some of these things can be trademarked, others can't. But some of the ways in which you can protect it is through contracts, but also just being the best and being the one that's consistent. I know Clinton and I have talked about cookies on the pillow. When I say cookies on the pillow, what do you think about, Clinton?
DoubleTree.
Right. I mean, yeah, there's no patent on cookies on the pillow. There's no trademark. There's no trade secret because people are gonna see the cookie on the pillow. But we know that resonates with you. Now you're like, wait a minute, DoubleTree. I'm expecting it, but I also feel something, and I'm gonna spend a little extra money because of this, this little treat. Same thing, I go and I want some chicken strips, and some waffle fries, and I get my bag and I say thank you. What is that person going to say, Clint?
We talking about Chick-fil-A?
I mean, you could have just said my pleasure, but we are
Oh.
talking about Chick-fil-A. We are, and these are things that are not trademarked, but they're tagged onto your brand, um, and that's important because you're building relationships. You're building universes and relationships, and people when people are close to your brand, close to your business, and they feel like they know you, they're going to spend money and they're going to be return customers. So part of your intellectual property is relationship building, and that goes through consistency, professionalism, and a lot of that. I do want to open the floor for questions. We this is a little different than some other seminars where we just talk and have a PowerPoint for an hour. We want to have you ask us questions, chime in. because we want to help. And a lot of times helping by just preaching to you is not the best. So definitely want to open the floor. Yeah. Do we have any questions yet, or we're still people are still shy?
I don't see any questions. I think everyone is just being shy.
It's okay. It's okay. I hope people get the moxie to come across.
One of the things you talked about in terms of social media kind of reminds me of um, when we were talking about name, image, and likeness. In my past life, I'm a former collegiate athlete. And in my current life, some of the work that me and my firm have done has been working with athletes in terms of name, image, and likeness, which as we know it today, kind of refers to collegiate athletes. And as of July 2021, NCAA athletes across all sports are allowed to finally be able to capitalize and leverage their name, image, and likeness for to promote a brand and make appearance, sign memorabilia, and be compensated for that. One thing I wanted to convey here, because I'm not sure there are any athletes or any parents or family members of athletes on here, is that name, image, and likeness is not just about athletes. It's not just about artists. It's also about brand owners. It's also about founders. It's also about creatives, right? Particularly like if you are someone who's like, hey man, I came up with a great barbecue sauce. It's called Clint's famous barbecue sauce, and your face is on it. Like your name, image, and likeness, and how you put it out there is important because now it's not just about the secret sauce of the recipe. It's not just about trademarking the logo, right? It's not even about maybe getting trade secrets on the recipe, right? It's also now about your face that is on that bottle, right? It's about your name and as you put it out in the world. Like, have you had an opportunity to go register the domain, right? Have you had an opportunity to go snatch up every single social media handle, even on platforms that you have no plans on ever using it on? Go get them because trying to get them later will be expensive and will be time consuming.
Someone has their hand up. I believe it's Bill. Sometimes a client brings a design to register a trademark. My first question is, where did you get this design and did you get the executive exclusive rights? My friend drew it and gave it to me.
Yeah, that is another. That's when you need a lawyer. I mean, really, and that's when we need to iron out a lot of the details before we get to that point. A lot of times, people don't read the fine print. So if I go on Fiverr and I say, hey, I need you to draw this logo, you need to make sure that you have the rights to that in order to use it. Plenty of times, people have yeah, I'll even say the rapper Cameron. There's a picture of him with a pink fur coat and a cell phone, and it's been an iconic photo of him. And he's used it multiple times, including in merch. He never got that copyright license and or ownership from the photographer, even though he is the person that is in the image. He did not have the right for that image, and so he's been sued multiple times, and the photographer won. There should have been a conversation early on about that, that photograph, and he would be able to, make money. So definitely, if you're want a logo made, your friend made it, even if it's your friend, honestly, have them sign over the rights to it, and pay them a nominal fee if you have to, if you buying pizza, but make sure that you have the rights. And I mean, a contract is the best, but you might be able to work with a conversation, in print, a text message or an email that may be able to work, but a contract would be best. So yeah.
A lot of photographers will have license agreements, right? Particularly like if you've gotten some package, like a headshot package, that will confer a license to you automatically. Well, not automatically, right? From the agreement. And if they don't have one, like you should absolutely ask. And a very specific example I will give is a couple of my clients. We're in a process of getting a book published. And one of the things that I've said to them 47 times at least is, hey, every image, like we need permission to use in this book. Every image, everything that we don't own, like we need a license for, like per the publisher. And it's like, well, what about this image? Like I'm in it. Yes. Like we need the photographer like to sign a release. It's like, well, these are headshots of me. We need the photographer to sign a release. Well, I'm in this photo. Well, there's somebody else in the photo. So we need the person in the photo next to you to also sign a release. So it is very important that you are on firm footing when it comes to images of you or video of you, like even if it is of you. Like make sure you have that license, make sure you have that permission to use it before you put it out publicly.
I assume we have a second question. What are the 3 recommended legal documents to protect your IP? Clinton mentioned a strong operating agreement and NDA, but I did not hear the first one. Do we have a third one, Clinton?
Oh,
Um,
the first one was just creating a company, to creating a legal home for all of these things, and there are a number of different reasons why you may want to use an S corp or a C corp, right? And the actual specific vehicle will depend on the jurisdiction you're setting it up in, the type of business that you have, so on and so forth. So I won't give a like the recommendation will be very specific to your business and the jurisdiction, right? But I will go with the example of LLC because it is one of the most prevalent, right? You do that, and the reason why is because of the liability shield that it will afford you, right? So that is why a lot of people say, "Oh, just go start an LLC." Sure, yes, right. For the example, but like you want a strong legal home for these ideas, for this well building that you're going to do. You want a strong operating agreement, as the questionnaire pointed out, and then you also want to have NDAs. The third thing that I would say, well, fourth, right? In addition to that, depending on the type of business, you would also want like a vendor template, right? Like have a standard contractor. If you hire a lot of independent contractors, have an independent contractor agreement. If your business is providing candles to the public and you're in a process of wholesaling them, right, or selling them to other commercial entities, having a standard vendor agreement that you can negotiate with various partners as you go along is important. So you're not reinventing the wheel every single time. And you have all of the protections that you want in there about intellectual property or licenses that you're granting or not granting, permissions that you're giving or not giving, and all the rules of the road that you have for your company are already in it.
Yeah, I mean, this is all of this information. These are those fences that you're building. These are those doors. These are those locks that if you're not able to have, Big Brother U.S. government have your back with, the intellectual property, types, you still are able to have some protection. And of course, you're going to need a lawyer because, if someone does violate or break some of these protections that you have, litigation. That's what's going to happen next. I do want to talk a little bit about, sometimes people talk about cost. They want to talk about, the price of things. If you're able to get a lawyer, absolutely, it's super invaluable. I'm not just saying that, but there's also resources. The USPTO has resources for individuals, especially patents. They can come and talk to a patent professional about some of their ideas to guide them through the process. The process for both um, patents and trademarks is not easy. It isn't. I think some people will tell you that it's super simple. I have one example. I was working with a music artist, definitely helping him with his career. I told him, my price, and I was lowballing myself, but I wanted to help him, and I let him know the prices of even with the copyright. And he went and filed a copyright on his own, did it all wrong, all of it wrong. And I will say the U.S. government does not believe in refunds. Maybe a tax refund sometimes, but if you fill a form out wrong, it's sorry, that money's gone. And he used the wrong forms, had the wrong classes, and yeah, that money was out, and he was too embarrassed to tell me until I found out later. Also with trademark, same thing. You're filing on the wrong class, you're gonna get multiple rejections. and you're gonna not know what to do with those rejections. So I definitely tell people to really consult with a lawyer. If you have to go the pro bono route, then do it. Every law school should have some kind of clinic. Not everyone has an IP clinic, but if you're in a space or a place that has, multiple law schools, definitely check into that, and really, learn. You should be savvy. I think, whatever you're dealing with, you should know a little bit and then pass it to the expert. You shouldn't go in there blindly. Definitely important. And I think that raising that intelligence, raising that understanding of what IP is. A little bit of my background before I got into law school, one of my uncles was a member of the Drifters and the old music group. He wasn't a new drifter. He wasn't the original drifter, but he was a new drifter. And he let me know the business practice in which the original drifters did not own the copyrights on their music. They didn't own the trademark for their group. So the people who owned it were able to profit, able to send multiple groups of drifters and platters and coasters all across the country to perform. And imagine you hearing someone else performing your music and you're not getting any money from it. So he definitely let me know that I should be in that space to help people protect their ideas and innovations, and it's so important. Yeah, but also ideas are important. I think that we do focus on intellectual property, but ideas and innovation is it's a snowball effect. So your first idea might not be your best idea, but in order to get to your best idea, you need to continue to ideate, continue to dream, continue to see the holes and what's profitable and have that eureka moments. It's corny, but I tell my internal clients that you might have a eureka, someone else might have a Kia, and you put it together and you have Eureka. So definitely collaborative, work, but with that collaborative work, you do need an operating agreement. You do need NDAs, et cetera, in order to definitely protect our intellectual property. Man, I actually love talking about this. This is my favorite thing. I do it for work. Also, I do it for fun. And I definitely brought in Clinton because we're both IP nerds. We both love comic books. We both love entertainment, music, and so we see that world building. We see that people are capable of inspiring us through their innovation. But we also know the stories of those who have not been able to protect their IP. And it's almost sad to see, a multi-million-dollar company based on someone's idea that person's family and lineage are not benefiting from. So these are, now that we know the rules of the game, we're able to share it and we're able to help those who are creatives, who are business people to protect their ideas, and really, create that generational wealth in reality instead of just a social media topic.
Any other questions about what we got going on? Anything that we've covered that you would like us to kind of expound upon even more, or?
This is your chance. It's free.
Exactly. We're not charging you this.
The rates are going up. Especially with Clinton. But my rates are JP Morgan prices. So
which is expensive.
Yes, it's crazy.
Well,
Ms. Walker, you're a 3L. Do you have any questions for some attorneys? Wow, that are seasoned.
I don't really have too many questions. Someone did just ask, you all mentioned trademarks. What's the difference between trademarks and service marks?
You got it, Quinn?
No, you got it.
That's messed up, man. Trademarks are, it's in the name, honestly. The process is the same thing, but a trademark is, I'm selling goods. A service mark is I'm selling services. So, if I'm selling something that's tangible, and, digital counts as tangible. A service mark would be, I am a delivery service. I don't actually provide anything that is physical. Um, so it would be a service mark. Um, but that trademark is used interchangeably. Like, trademark is the overarching thing. So sometimes it's just used as a trademark, even though that thing would be a service. And a trademark would be goods. Um, I do have one of my law school classmates, Lauren Burke, is in the audience. Everybody, give a round of applause for Lauren Burke. She will be doing a future IP for the People event, and she is a trademark attorney. So I know she would have had a very, very detailed answer for that. So you should definitely tune in to Lauren Burke's wonderful IP session.
So one of the things I would like to kind of share as we get ready to wind down is just the importance of, to the best of your ability, doing it right the first time. And I know this may sound so serving as an attorney, but trying to clean it up later is very expensive. But it is not that we're charging you more, right? It is that it's more work. Like, it literally is just more work to fix an intellectual property problem after the fact than to be proactive on the beginning. One of the things that we touched on earlier about the importance of strategy, and one of the reasons why we offer that as part of what we do is because it's also kind of a way to kind of save money. An example I will give is one of my earlier clients. It was actually still a current client. Runs a fashion company. Like, they literally make handmade premium leather goods, and they've had their products on a number of different celebrities. As recent as like Ryan Clark on ESPN. So as they were getting ready to start out, like, we go through the whole process of like, hey, how much to get my logo and get my work trademarked. And he had no idea that his work would span so many different classes, because you just think, hey, I'm making leather, that's just one class. But he was making leather bags, he was making leather book bags, he was making leather purses. And as intuitive as it might sound that it should all be one class, it wasn't. So what happened was we gave him what the prospective bill was, and he said absolutely not. It's like, and not even just our fees, is again just what was going to go to the USPTO. So we devised a strategy about what was near term, right? What's ready to go? What's your number one seller right now? Because he'd already been in business. And then, okay, what's going to come out next quarter? Right. And then we kind of devised a strategy about how to leverage what was going to make him money now, and then also fuel and pay for the dreams later on. So you wasn't coming out of pocket with thousands of dollars at the outset to kind of do this thing. And that's one of the reasons why you consult an attorney at the beginning as opposed to after the fact, because he could have just been discouraged and not done anything at all, and it would have cost him. Because having his work on ESPN and on Monday Night Football has been huge for him, because Ryan Clark, as many as some of the other celebrities that have talked about his brand, like, have like completely overhauled what he's doing on social media. So I say that to say you need to at least be told what the price is before you say I can't afford it. So go ahead and do that due diligence. Continue to dream and continue to do the work. Because one thing I know about small businesses, as from my clients and even for folks who are not been my clients, is like, at any given moment it can take off. And if you are not ready, if you have not laid the foundation for it to take off, it can be overwhelming. Just as many people who have made it big on Shark Tank because they were able to harness the power and the strength of it, they've also bankrupted a lot of companies because they weren't ready.
Yeah, and just to echo some of Clinton's statements, I remember when I was a young patent examiner, I had a guy who put his life savings into getting a patent. Like he knew he needed to get a patent for a board game. And I tried to tell him, like, please stop submitting these fees. Please stop, paying those lawyer fees, because you're not going to get a patent. Like, I'm sorry. Like, I've found it a million times. I've found it a million times in a million ways. And I know you really want this, but like your tunnel vision of I get a patent, I get rich. That's not how it works. You have a great product that you're able to protect and then sell it to someone else who buys it, and then, or you have a great product, you protect it, and then you're able to sell it. That's how you get rich. A patent is just one avenue. And a lot of times, if you take that money you would have been spending, for a lot of these, services and fees, and put it into your business, you would have done a lot better. You definitely, instead of getting that patent, trademark that name. Make sure it's the best product on the market. Make sure that, it has the best advertising, best marketing. Make sure that it, has, the best customer service, the level of professionalism. Make sure that it piques people's curiosity, because that's how you get, where you want to be. I mean, Clint and I were talking about hamburgers. If one person would have said, man, they invented the hamburger, I guess we got to go make something else. No, they recognize the market. They recognize that, hey, I can put my spin on it. I can create my brand. I can create, a fan base from that. And I might not actually have a patent. I will have a trademark because I want people to come to me and know it's me. But I didn't necessarily have the need or have the ability to protect that particular idea. So there are ways in which, with that NDA, with that operating agreement, with that business structure, with your relationships, your vendors, and really your relationship with your customer base, these are ways in which you're able to protect your ideas, and make them see you as the business that you are and want to be. And that's super important. And like also like Clinton said, keep innovating, keep creating ideas, even if it's just for yourself. I think that owning your personal brand is a form of IP. The way you show up, if you're not an entrepreneur, you don't want to enter the business world, the way you go to school, the way you show up, in class and into networking, the way you show up at work, the way you're able to network and to your work product is part of your IP, and that helps your career. So you can own your brand, even if it's not a traditional trademark. You have your own trademarks as a person. So having that concept that intellectual property is real property, and I own the things that I create with my mind, it changes something in you, and makes you more intentional about your relationships, both personal and professional. Get 2 more minutes. It's a countdown. Anything you want to plug, Clinton? Let them know how they can reach you, see you, engage, because we're not just talking to the people that are here today. We're talking about the people that are here tomorrow. They're going to stumble upon this, and et cetera.
I do have a mixtape coming out. I would love to play for everybody right now. No, I'm kidding.
No, I'm serious. If you got a mixtape, I want on it. Now, let me get on the bonus track. I'm still working on mine. Coming in 2025. So, really, maybe 2026, depends on my work schedule. But yeah, it's important.
In all seriousness, guys, I enjoy doing this. Especially anytime I get an opportunity to kind of work with Kaz, who is not just a classmate of mine, but also a good friend. And we do nerd out about IP all the time. But if you guys have questions later on afterwards, like, please consult this. Thanks to everyone for showing up tonight. Like, really appreciate you guys. Like, Diplomat Enterprises, like, you type it in, I am going to be the only one, or the company is going to be the only one that shows up. So that's fairly simple and straightforward. I would love to hear from you guys. If you have any questions or concerns about IP or legal branding for operations.
Same with me. You can find me at, on LinkedIn, Lawrence Cosby. That's where, I can field your professional questions, networking, et cetera, down the road. Yeah, I love working with Clinton. Close friend, definitely a colleague, great legal mind. Sometimes we back and forth with each other in order to, really get answers. And sometimes I jump in and I help diplomatic enterprises, ad hoc basis. I'm just there to really help my brother. But also thank you for IPSHA and IP for the People for allowing us this platform to really talk about what we talk about.
Thank you. Thank you all so much. Truly, that was a wonderful presentation. I really want to thank you all for being so informative tonight and serving as guest presenters for the IP for the People webinar series provided by the Institute for Intellectual Property and Social Justice. I definitely learned something new today, and I really hope that everyone in the audience did too. Luckily, this is all recorded, and we'll be sharing this on our YouTube page at a later date. We'll be sending an email out once that's uploaded. We hope that you'll subscribe to our newsletter so that you can be informed of future events, including the next session in this webinar series, which will take place on January 15th. This session will focus on how to avoid pitfalls in the trademark application process and will be hosted by Lauren Burke, a senior trademark counsel at Jordan IP Law and a former trademark examining attorney. So thank you to all of our wonderful speakers again, and our moderator, and to everyone who participated tonight. I hope you all have a wonderful evening. Thank you.